some QA requirements in taking the exam. They also, and you've probably heard of this, people coming in from other jurisdictions where the educational system is a little bit different can be registered as a full registrant at the outset if they're assessed and determined that their educational and work experiences are substantially equivalent, say, to what dietitians have here. All of the colleges do that because of all of the international movement that takes place worldwide. And so there are these what are called substantial equivalency provisions under the main full registration provisions. So what the review board did was they decided that she didn't have to come in under the reinstating provisions. The college was required to assess her and determine whether her knowledge was substantially equivalent to that of in this case, a chiropractor. And if it was, then she had to be let back in. So they sent it back to the registration committee and said, you have to ignore your own reinstatement bylaw and look at this subsection on substantial equivalency under the full registration provisions and decide whether she can get in. So I won't go into the legal analysis, but all of the colleges and the Ministry of Health lawyer that we deal with in Victoria think that the panel's legal analysis here was quite incorrect. I'm certain that if it had been appealed, the review board's decision would have been overturned. But in that case, I think the College of Chiropractors was tired, and they didn't really want to spend the money because this lady was sort of on the cusp. She was only out right on the dot of 3 years. It wasn't like she'd been gone for 6 years or anything like that. So they felt, I think, that they could safely let her in to practice again, and they did. So they didn't appeal the decision, so it's on the books, but it is thought to be wrongly decided, and all the colleges are scrambling around trying to change their bylaws to plug that little loophole so that we're not faced with the argument that this lady made again. So that's one of the best examples that's out there of how the review board can muck things up. Oh yeah, this is another interesting little case. The College of Dental Surgeons refused to refer a complaint regarding a financial dispute between a dentist and a patient to the inquiry committee. There are no details given about what the financial dispute involved, but we can just assume the dentist wanted a lot of money for a service, or something happened during the course of the dental treatment and he or she had to add some additional treatment, and then the patient didn't want to pay for it. So in this case, the college, as I said, decided this is a commercial dispute. It's a business dispute, and it's not about professional misconduct, so we're not going to consider it, and they didn't. And the complainant, who was obviously very mad at her dentist, asked the review board to review the complaint and the disposition by the inquiry committee. And the Health Professions Review Board disagreed with the college's view and said, no, a financial arrangement can constitute professional misconduct. So you've got to investigate it. And I actually think the review board got this one right, because we don't know anything about the facts in this case, but I'm assuming it was something that really was kind of a commercial thing, just about the money. No rudeness, no misconduct, no bad incompetent practice was involved. But you could see with some of the paying professions, perhaps a vulnerable elderly person goes in to see a dentist, and the dentist, or one of the other professions where you pay for services, decides to take advantage of this elderly vulnerable person. That could be professional misconduct. So that's all the review board is saying there. They're just saying you've got to investigate it. Doesn't mean you have to do anything with it. So that case, the dentist lost that one. Oh yes, this one. This is another dental case. They've really had a lot. I don't know why, but so the complainant didn't think the treatment that she'd received from a dentist was very good, and she complained that her veneers had fallen off. She didn't like the way he'd replaced and removed crowns, and generally the treatment of certain of her teeth. And the registrant's response was that her problems were caused by natural tooth decay, teeth grinding. She didn't see the hygienist enough, and she refused to have radiographs. So we could go to the next slide, Melody. So the college actually did a very good job investigating this. They considered the complaint, they obtained detailed information, they got the chart and patient records from the registrant and other dentists who treated the patient. They looked at digital radiographs, and they prepared a 4-page chart analysis. And meetings and consultations were had with the registrant and another practitioner who had treated the complainant. There were some other records available, but the college in that case elected not to get them. They just made a judgment that they'd done enough. They didn't have to go further. And this complainant just couldn't rest, so she complained. And the committee decided that the treatment was appropriate and met the standard, so they weren't concerned about the dentist. And so what I like, this is where I have quite a lot of hope for how the review board is going to go. They said that the complainant was not entitled to a perfect investigation and that it must be just adequate. So they stuck to the wording in the legislation. Then trying to determine what does adequate mean, they said it depends on the facts, which I think is true. It will depend on the facts. And they said the investigation doesn't need to be exhaustive to be adequate, as long as reasonable steps are taken to obtain key information that affects the assessment of the complaint. And then the degree of diligence in the investigation required to be adequate will vary. And so in that case, they just held that it was adequate and reasonable, and the college won its case. So those are just a couple of examples of the review board and how it's operating and how it affects and works with colleges. So on the consent issue, I am aware that some of you might have questions about consent, and I can try and answer them, but it's such a complicated area, and the legislation is about to be dramatically changed. So I didn't really want to get into it until, first of all, the legislation is actually proclaimed in force. But the one thing that I'm pretty confident is going to happen is that advanced directives are going to be legislated and become operative. And that will start in September of this year. So the Healthcare Consent Act, what it does, or did when it first came, was it simply codified the common law duty to obtain valid and informed consent to healthcare from an adult. It does not address infants' consent. It established a system of substitute decision making. It set out a default list of temporary substitute decision makers, so that if a person goes to the hospital, say, who doesn't have family members, no spouse who can give consent to healthcare on their behalf, there's a default list of people that a hospital or any other healthcare provider can go to get substitute consent. So this is the name of the statute that's going to amend the healthcare consent legislation to add in advanced directives. And it's going to permit adults to give instructions to give or refuse consent to a particular healthcare in advance, provided the adult is capable of giving those instructions at the time. And the Act creates a number of criteria that have to be met in order for an advance directive to be valid. So it's not going to be easy to create these advance directives, in the sense that there's a lot of hurdles. Hurdles is probably too strong a word, but a number of criteria that have to be met for the advance directive to be valid. It's also, and this is why I didn't really want to get into it in detail, it's going to create a new system of guardianship. So we're going to have a lot of new terminology. The comitees under the Patients Property Act, that act is going to be abolished, so we won't have comitees anymore. So I've suggested to Fern, I think that maybe when the act, when all of these legislation amendments come into force, perhaps a little article in your magazine, maybe you might need more than one over 2 or 3 months or something like that, could be written to help you at least learn what the terminology is. Okay, so the last area I was going to cover was access to information and privacy rights. So as you all know, I'm sure we've got the Freedom of Information and Protection of Privacy Act and the Personal Information Protection Act. So what Freedom of Information, I call that FOIPOP, that applies to your college. It also applies to all of the health authorities. Most of the different kinds of publicly funded healthcare facilities of any kind are caught under FOIPOP. Dietitians that are working in private practice are caught by PIPA, the Personal Information Protection Act. So I work the most with FOIPOP, and in fact the Privacy Commissioner has been involved in really quite a few cases coming out of the colleges and the Law Society as well. So this is an early case in 1998. The Society of Massage Therapists wanted the College of Massage Therapists mailing list because they wanted to market insurance programs that they had developed. And not everybody was a member of the Society of Massage Therapists, so they wanted to get the mailing list. The college at the time couldn't distinguish between what was personal information, in other words, a home address, and what was work contact information. And you may not realize this, but your work contact information is not personal information. So colleges can, if they want to, give out that information. But home address is personal information, and they're not entitled to give it out unless there's a provision under FOIPOP that permits it. So in this case, the college said they couldn't give it out, that in this circumstance, the personal information was going to be used for a mailing list, which is an explicit prohibition under FOIPOP, and the mailing list was going to be used for solicitation, which it was. And so they didn't give it out, and the commissioner upheld the college's refusal, which seemed to me to be kind of a no-brainer. But nevertheless, the commissioner did the right thing. And then in this next one, let me remind myself. Oh yes, this was a former doctor who was having trouble living with himself, and after he lost his license in the College of Physicians and Surgeons, and he was bothering everybody. So he had lost his registration, and he made a whole large number of FOI requests to the college covering all sorts of things. He sued the college unsuccessfully in defamation. He made a complaint to the ombudsman about how the college had treated him, and the ombudsman didn't treat that complaint seriously, and it never proceeded. And he unsuccessfully complained to the Human Rights Tribunal. I think they didn't accept his complaint and didn't pursue it. And this was an interesting case. One of his FOI requests sought contact information for certain individuals. And you could go to thanks. The college didn't want to give out the information, including work contact information, because their experience with this former doctor was such, they knew that he would just harass these individuals. And once he knew where to reach them, they would never have peace. So they refused and said that the notion or concern they had that this person would harass them constituted harm within the meaning of the act. And if a college thinks that a third party